Christchurch.
That brings to a close questions for oral answer today. I call on Government Order of the Day number 1.
Mixed Ownership Model Bill, committee stage continued.
I declare the House and Committee for further consideration of the Mixed Ownership Model Bill.
Mr. Speaker.
Mr. Chairman.
Excuse me, I've got to say on behalf of Tony Ryle, don't I?
Yeah.
The House is in committee. Kia ora tātou no reira te whare inga iwi, inga rio, inga hawe wha tēnā koutou katoa. Greetings, honourable members. The House is on committee on the Mixed Ownership Model Bill, and the committee is resumed. Members, when we were last considering this bill, we had completed voting on Clause 2. I understand the Minister now wishes to move a motion dividing the bill.
Mr. Chairman.
I call the Honourable Minister Maurice Williamson.
Mr. Chairman, on behalf of the Honourable Tony Ryle, I move supplementary order paper number 41, dividing the bill.
The question is that the motion be agreed to. I call the Honourable Leanne Dalzell.
Mr. Chairman, I want to speak on this particular motion that has just been moved by the Minister and the Chair, and I hope he takes the opportunity to respond to the issues that I want to raise at this time in the debate, because this has been a very long debate that we've had on this particular bill, and I know that every member on this side of the House has been expressing the concerns felt by most New Zealanders that this bill should not be traversing through the House in this manner.
I know the member's going to... Can I just inform members that this is a very narrow debate, and I want to refer members to Speaker's Rulings 120/5. In fact, this is one of the most narrowest debates we can have. And so, to quote from the Speaker's ruling, it says this: "A debate on a motion to divide a bill is a very narrow debate. It is not an opportunity to recanvass all the principal issues contained within the bill. It is strictly related to the proposal that the bill should be divided." And so what the debate here really is this afternoon is whether this should be split into the State-Owned Enterprise Act or the Public Finance Act bill. So the member can say whether she believes it should be split into those bills and give reasons why, for or against. It's a very narrow debate. I call the Honourable Leanne Dalzell.
Thank you for your assistance, Mr. Chairman. I want to ask the Minister a series of questions about the motion that he has just moved in the House, which is specifically in relation to dividing the bill that we have been debating over the last few days into two separate bills, one of which would be enacting the State-Owned Enterprises Amendment Act 2012, and the second one that would enact the Public Finance Mixed Ownership Model Amendment Act 2012. Now, I understand that the reason that the government wants to divide this bill into these two separate bills is because the first part, clauses 1 and 2 and part 1, the reason they want to have that as the State-Owned Enterprises Amendment Act 2012 is because it takes 4 separate state-owned enterprises out of the coverage of the State-Owned Enterprises Act. As I understand it, and I would like the Minister to confirm this, that this would mean that the 4 state-owned enterprises, and just to recap, they are Mighty River Power, Meridian, Genesis Energy and Solid Energy, the 4 energy companies that I've just mentioned, that would then mean that they would no longer be state-owned enterprises. So that's the question I have for the Minister. Is the reason that the bill is being divided off, or clauses 1 and 2 and part 1 being separated off into a separate bill, is the reason because those 4 energy companies will no longer, in fact, be state-owned enterprises? Well, I don't know. I mean, I just would like the Minister to stand up and confirm whether or not I have correctly understood the purpose of separating off clauses 1 and 2 and part 1 into a separate bill. So that's the first question. Now, I understand that the second question would relate to the separation off of the remaining parts of the bill, which is actually just part 2, that would then take it into the Public Finance Mixed Ownership Model Amendment Act. And I just wanted to question the Minister as to whether the reason why this legislation would be called the Public Finance Mixed Ownership Model Amendment Act, is that because the decision was made by the government to call the privatisation of public property a mixed ownership model rather than a former SOE or a privatised state-owned asset, or, you know, one of those different ones. And I know that we did debate those, and it would be inappropriate for me to raise the actual topic of the debate in the context of this. But is that the reason why the Public Finance Amendment Act actually requires the words mixed ownership model to be in brackets as part of that act? And is that because it needs to be separated out from other elements of the Public Finance Act, something that wouldn't actually be required if they were in fact still state-owned enterprises? Because again, as I understand it, if they were state-owned enterprises, then we wouldn't need the first part of this particular piece of legislation. They wouldn't have to be split into 2 separate pieces. And, it is a serious question, and I think that we have really taken the opportunity on this side of the House to ask all of the questions that the public have wanted to have put to the government. Mr Chairman.
I call the Honourable Leanne Dalzell.
Mr Chairman, thank you for the opportunity to continue down this path, and I am disappointed that the Minister hasn't taken the opportunity to respond to these questions, and perhaps he simply hadn't taken advice in preparation for participating in this debate. He may in fact be surprised that we are debating what is not normally debated in this House, but because this is such an important piece of legislation, I think it is important for us on this side of the House certainly to raise all of these questions, because I don't know about other members on this side of the House, but I have been inundated with a large number of inquiries from the public, perhaps not necessarily about this particular motion, because they may not have been aware that this motion was going to be moved by the Minister today. But I do know that all the other elements of the legislation have been the subject to a significant amount of approaches to this side of the House, certainly. And actually, I suspect members of the government have received a lot of feedback from constituents and from their own supporters, very concerned about the decision. Well, it's interesting that the Minister interjects from the other side of the House and says that there was a general election. There was one last year, and that is true. But there is also the point that was made by my colleague Grant Robertson, a very good point, which was when you add up the numbers of people who voted against national or voted for parties. Well, I'm responding to the interjection from the Minister, and I think it's only fair that if you add up all of the people that voted for parties that were opposed to the sale of state assets, then that was the majority decision, which is reflected in the polls today. And I think I'm getting a signal from the Chair that I am to keep this to the narrow parameters of the debate, but I think he has accepted that it is appropriate that when I'm interjected by someone as important as a Minister, that it is important to place that interjection on the record and to respond to it, and I thank the Minister for the opportunity to do so. Mr. Chairman, the Minister in the chair, though, still hasn't taken the opportunity to explain why we are dividing this into the two separate bills. And I really think that it's important to this House that we receive the confirmation that we are looking for, and that is around the decision to have the Part 1 and Clauses 1 and 2 now known as the State-Owned Enterprises Amendment Act 2012, and the Part 2 and Schedules 1 and 2 actually to be a separate bill under the Public Finance Mixed Ownership Model Amendment Act. And I think that the fact that the government has decided to split them into these two bills, and the reason why they've chosen the name Public Finance Mixed Ownership Model, that's the question that I do think that the government does need to respond to in this debate this afternoon. But also, more importantly, the decision to use the State-Owned Enterprises Amendment Act description as the coverage of the Clauses 1 and 2 in Part 1. And I think the main reason that that needs to be really dealt with is the confirmation that it is because there are 4 SOEs today that are not going to be SOEs when the State-Owned Enterprises Amendment Act 2012 Act becomes law. And I think that is probably the most important question that the public would expect the government to answer in the House this afternoon as we come down to the very final parts of the committee stages of the what was going to be formally known as the Mixed Ownership Model Bill, if this motion is agreed to by the House. Now, I should say that I understand that we will not be supporting this motion, and the reason that we are not supporting this motion is that we haven't really found any reason to support any element of this legislation. It is not supported by the general public, and actually there's no reason to separate out this motion from any of the other motions that have been having to be challenged on this side of the House, other than the very good set of amendments that we have put up in this matter. Now, we didn't put up an amendment on this particular motion, and that's because the motion hadn't technically been moved when we were still debating within the broader committee stages.
I call the Honourable Member Russell Norman.
Thank you,